If you're questioned by police, it can be a stressful experience, but new evidence suggests that the way the interrogation proceeds could actually have a big effect on what you say.
Common police tactics can actually make you believe that you've committed a crime when perhaps you had nothing to do with it.
And joining us now to explain this, we have Jeff Manishen. He's a criminal lawyer who also has experience as a Crown attorney. So, Jeff, it sounds more like the plot to a good movie. How can police actually plant false memory during an interrogation?
Well, police use a technique that's called the Reed technique. That was the name of the author. It's a study that it's a book that had come out some years ago and has done a variety of, come out in a variety of different iterations. And what they do is they basically treat the individual from the standpoint that the police know the individual did it. They just want to know how and why it happened. And they will indicate they've got incontrovertible evidence. They will offer reassurance that they're here to be able to listen, that this could be the individual's one opportunity to be able to tell the story, that they will be reluctant to accept any kind of denials. And it will happen, it can happen, that by a suggestion, the police can ultimately get people to admit to things that they didn't do. A recent study done by some psychologists from the University of British Columbia and from the UK have indicated, using university students, that you could actually, by powers of suggestion and various interrogation and other methods, get people to believe they actually had committed crimes that they hadn't done.
So it's a form of mind control. It's a form of coercion. It may be involving things like sensory deprivation. It seems to me, Jeff, like it's a form of torture. So if you had a client that was picked up by police, what would you advise them? What rights should they know about before the interrogation even takes place, so they're not put into that position where they might unintentionally incriminate themselves?
There are a couple of features that the person should know. Number one, they have the right to silence. It's provided for under the Charter. But something they should know, too, and the Supreme Court of Canada has interpreted it this way, it is not as simple a matter of saying, I don't want to say anything, that the police then have to hold off and not question further. In fact, you know, Mark, there are no actual upper limits on how long the police can question the person, or how many times the person has to say, I don't want to say anything, for the police to then have to stop. Because the courts have looked at it from the standpoint that even after extensive questioning, if the person finally starts to talk, the court may well say, well, the person chose to give up his right to silence. It's only if the questioning becomes so oppressive that the person's will to choose is really overborne,
well, who makes that determination?
The statement could be thrown out.
Jeff, who makes the determination? If there isn't a lawyer present, who determines whether the questioning is oppressive or not?
That's another issue. There's no right to have the lawyer present. So it's something a court would have to decide subsequently. So step number one is to tell the person, you do not have to say anything, you have the right to silence. Number two, the police can go on and question you extensively, and you just simply repeat, I don't wish to say anything. Number three, the police may say this is your one opportunity to tell the story. No, it's not. That opportunity could come up later on at trial. Number four, the police might say, we know you did this, all we want to know is how and why. Or they might say, what would you say to the victim if he or she was here? All those things are designed to be able to influence the person to believe that it might be to their benefit to be able to cooperate. Now, the police are not allowed to threaten and not allowed to offer any kind of inducement, but they want to try and get the person to talk. And it can even be the case a person under stress might say some things which might be a denial but might not be accurate. That person could later be cross-examined on those things at trial. And remember, if a person makes a basically exculpatory statement, the Crown doesn't have to lead it to trial. They can simply say, we aren't going to rely upon that, we aren't going to introduce that. So these are all features for the person to understand. It is rarely in somebody's best interest to talk to the police when under interrogation. Much preferable to have the opportunity to talk with a lawyer outside of the police department and get an idea as to what their rights are and what their position is.
Okay, so Jeff, let's say I have found myself in this situation. I felt the pressure, the need to speak to the police. I thought it was the right thing to do, and I inadvertently admitted to doing something that I didn't do because of these tactics. What is my recourse once I've, separated myself from the situation, spoken to a lawyer, and realized what the heck just happened?
Well, what will happen, Liz, is this. We'll certainly look to, number one, challenge the admissibility of that statement at the trial to see whether or not it could be excluded. But number two, you'd certainly be entitled to testify as to how and why you came to say the things that you did. An area that's really problematic right now, I would like to be able to lead evidence. A good friend of mine is a professor at York University named Tim Moore, who's done a lot of work on false confessions. I would love to be able to call him to say there is a phenomenon of false confessions. It does happen. You know, that kind of evidence is generally considered to be not admissible. Why? Because judges feel, well, we can decide. We know some people may falsely confess. They may even need to tell a jury some people do falsely confess. And it does happen. And that's a very real issue. A confession is something that has generally been considered to be pretty strong, compelling evidence, and it can lead to wrongful convictions, because there are false confessions. We've seen it a lot of times, both in Canada and the States and elsewhere.
Let's talk about another story here. It's about this hunger strike at the second largest jail in Canada. That's the Toronto South Detention Centre in Etobicoke. They're protesting the conditions there. Jeff, do you know how bad are the conditions that these people want to go on a hunger strike?
From the things that I've read and heard, Mark, it's not only the physical environment that there are issues with respect to the air, with respect to the flooring and windows and circulation matters of that sort, but in addition, there have been a regular number of lockdowns. That means that people are confined to their cell with limited access to be able to get out and even just walk around. And remember, the cells, it's not uncommon to have 3 people in a cell meant for 2. You can have lockdowns for security reasons. It seems from the correctional officers, they've said they're understaffed. They should have 700. The article I read said they had 400. And what happens then is not only are the people, and remember, these are people who frequently are presumed innocent, haven't yet been sentenced to anything, just couldn't get bail. They're confined to these really restrictive conditions, can't get to meet with their lawyers, can't get any kind of exercise or out. So what have they done? The only thing they can do is they've gone on a hunger strike. And apparently guards have let it be known that they have some real concerns too. There hasn't been that great response from the provincial ministry to deal with it. And it's not an uncommon problem. I know in Hamilton we've had problems with 3 in a cell meant for 2 for some time. We've had jail guards here, many of whom I know and like and respect, have tried to raise these issues. It is a province-wide problem, Mark.
I'm just wondering what kind of rights you have when you find yourself in that situation. I mean, you know, is there a certain level of the kind of environment that you deserve, especially even if you are in jail? You know, in terms of there's a question about mold and being locked down, so even up to 4 days where you can't leave your cell. I mean, those are the kind of things that someone has rights and they can actually maybe go back and sue the jail.
In fact, Liz, in the States, I think it was in California, prisoners who were kept in extremely harsh, difficult conditions, almost in violation of the United States Convention on Human Rights, they sued, and they effectively characterized it as cruel and unusual punishment.
Right.
And it led to court decisions saying a whole lot of them ought to be freed to allow for more space in the jails. That could happen one day here. We have a provision against protection against cruel and unusual punishment, and if you could build a strong enough evidentiary case, sure. Class actions as well, potentially. I think the real difficulty is that prisoners, people who are being held without bail, don't have a lot of voice.
Yeah.
And the public doesn't have a lot of sympathy for them.
Right.
And correctional officers, as I say, over the years have tried to step up and say, we have conditions that are unsafe. It's unsafe for us. It's unsafe for the inmates. We have increased incidents of violence.
Right.
So who's going to listen to them? That's where the government has that responsibility. And to go to the extreme of a hunger strike is really pretty exceptional. You'd like to think someone will now take notice and act on it?
Let's hope so.
Yeah. Well, 700 staff must mean there's a lot of inmates. Thanks to Jeff Manishen, criminal attorney, for being with us today. We appreciate your time.
Always my pleasure, Jeff.
When we come back, the founder of Facebook has pledged to give away almost all of his shares to charity. Now that, Mark, is inspiring.
Come on, Liz. If he really was a charitable, sincere person, he would have donated the money anonymously. We'll debate that next on Square Off.